So a case challenging the NFA and its restrictions on SBRs is now being sent for review in front of the Supreme Court. In this case, the Trump DOJ continues to argue against the Second Amendment, and they argue that the NFA's SBR restrictions do not in fact violate the Second Amendment. Now, this is coming in a case called U.S. versus Rush, and it's a challenge to the NFA and its SBR restrictions, and like I mentioned, this is currently in front of the Supreme Court. This challenge asks for the Supreme Court to find that the NFA's restrictions are unconstitutional under the Second Amendment and that it violates precedent like Bruin. Now, the petition also focuses on the Supreme Court finally needing to step in and correct the lower court confusion on what type of arms are protected by the text of the Second Amendment. In this case, we recently got the response of the Trump administration, and in that response, the Trump DOJ continues to argue that the Supreme Court should not actually review this case, that they should deny cert in this case, and they still argue and believe that the NFA has at least some circumstances where it's valid, and therefore the facial challenge that was brought by the petitioner should fail and this case should be dismissed. Now, even more interesting, they argue that the underlying question on whether SBRs are protected arms and have two-way protections is a question that should actually be answered in a different case. The Trump DOJ calls for the Supreme Court to take up a different case, not this one, but they argue that maybe something like a state AR-15 ban is a better vehicle, a better case to address this whole arms ban question. Well, now this will go to the Supreme Court for consideration on December 12th, along with another SBR challenge called Robinson. So 2 NFA SBR challenges will go in front of the Supreme Court for conference, and we're going to find out what the Supreme Court wants to do on this NFA issue. Now, I will state the likelihood is that the Supreme Court will not take this review. They will not take this case. It's likely that they will agree with the Trump DOJ's recommendation and decide to punt this case. But that does not mean that they're going to take the other Trump DOJ recommendation, which was to take up a state rifle ban question and deal with these whole arms ban issues that have been very prevalent in liberal states like California, New York, New Jersey, Illinois, Oregon, Washington, Colorado. I can list off a bunch of states that have these types of rifle bans. Now, before I dig deeper into what is currently going on in this case, which is seeking Supreme Court review dealing with NFA restrictions on SBRs, I just want to thank one of the main supporters of this channel, which is Attorneys on Retainer. You guys know that when being a Second Amendment advocate in concealed carrying or maybe constitutional carrying, you can find yourself in a situation where you have to use your firearm self-defense. And I highly recommend that you check out AOR. In my opinion, they're the best self-defense program on the market. They're backed by an actual law firm, Attorneys for Freedom, and they are always expanding upon their benefits. Recently, they expanded their benefits to guarantee that you'll get 4 attorneys on your self-defense case. So again, check them out using my links down below. I highly recommend you sign up this year to lock in your price. And if you sign up using my link down below and use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. So now let's jump back into what is currently going on in this case seeking Supreme Court review. Now, for those not aware, in this case, Mr. Rush was charged with possessing an unregistered short-barreled rifle in violation of the NFA. In February of 2022, a police officer saw Mr. Rush, who he believed, or I believe he had some sort of information that Mr. Rush did not have a driver's license. It had been revoked. But he saw Mr. Rush pull into a driveway with his truck. It was across the street from a courthouse. Mr. Rush got out of the vehicle, walked across the street, went into the courthouse for an appearance. Now, after leaving the courthouse, he walked back across the street, went into an apartment complex where I believe where his sister lived. Later on, the sister left the apartment, got into Mr. Rush's truck, and then decided to drive away. She was going somewhere. Now, the police officer decided to stop the sister in the truck, asked her if Mr. Rush had actually drove that truck to her apartment. She said, yes, he did. They called Mr. Rush. The officer, Mr. Rush, had a quick conversation on the phone, and Mr. Rush agreed to come out and talk to the officer. Now, after that, the officer was looking into the vehicle and he saw what he thought was marijuana in the center console. And because of that, the officer began to search the truck. Now, about that time, Mr. Rush arrived there where the officer was, where the truck was. And as the officer was going through the vehicle, Mr. Rush opened the backseat door, reached in to grab something. The officer kind of struggled with him, and then eventually Mr. Rush was handcuffed. Now, actually what ended up happening as well is there was an SBR on the floorboard of the truck. Mr. Rush said that he was trying to grab the rifle and run away, but of course he was restrained and arrested. Because of this, Mr. Rush was charged with possessing an illegal SBR in violation of the NFA. Mr. Rush argued that the NFA's registration requirements infringe on his 2A rights and therefore the charge should actually be dropped. The district court on review denied that motion, concluding that short-barreled rifles are dangerous and unusual firearms and therefore they are not afforded 2A protections. This then was appealed to the 7th Circuit, who on review affirmed the district court's ruling there, relying on the Supreme Court's precedent in U.S. v. Miller. The 7th Circuit found that Miller remains controlling precedent, and the NFA's restrictions are consistent, and they're consistent with the historical traditions of regulating so-called dangerous and unusual firearms. Mr. Rush has now filed a petition to the United States Supreme Court asking for them to reverse that lower court decision and find that the NFA and the SBR restrictions under the NFA do in fact violate the Second Amendment. Now, like I mentioned, the Trump DOJ originally decided to waive their right to respond to this case, waive their response to the petition, but the Supreme Court ordered that the Trump DOJ file a response. Now, recently, the Trump DOJ did file that response, and in it, the Trump DOJ continues to argue that the petition should be denied and that the NFA is facially constitutional. They argue there is some valid applications of the NFA in the Second Amendment realm, and therefore it survives a facial challenge. They also argue that this case is not the proper vehicle or not the right case for reviewing and deciding what type of arms are afforded 2A protections. They argue instead that the Supreme Court should simply kick this case and then take up maybe a different case like a state rifle ban challenge to answer that type of question. Now, in response to that, Mr. Rush argued in his reply that this court's precedent makes clear beyond doubt that the Second Amendment's plain text extends prima facie to all instruments that constitute bearable arms. Yet the 7th Circuit panel below denied that the NFA's registration and taxation requirements for short-barreled rifles even implicates the Second Amendment's plain text, when the lower court's Second Amendment jurisprudence deems ordinary, long arms to fall outside the text of the amendment altogether. That is a sign that the jurisprudence has taken a dangerously wrong turn. This court should therefore intervene. Here in Mr. Rush's response, he starts by pointing out how far the lower courts have gone to essentially twist Bruin and the Second Amendment jurisprudence, and how they've essentially done everything that they can to say that a lot of firearms, including SBRs and other items, do not fall under 2A protections. He goes on to state that the government does not defend the panel's refusal to recognize SBRs as arms, and the feeble arguments it does advance in an attempt to justify the result below all fail. Its argument that Section 5861D's regulation of SBRs is consistent with the nation's historical tradition of firearms regulations is based on a smattering of laws enacted 45 or more years after the Second Amendment's ratification. He goes on to state that the government concedes that the decision below raises fundamental questions about the application of the Second Amendment that have bedeviled the federal courts of appeals and may well warrant review by this court. He concludes by stating that this case presents the court with an opportunity to address and resolve one or more of those questions in the context of an anomalous federal law that restricts the possession of common firearms that no one can plausibly claim are unusually dangerous or especially susceptible to criminal misuse. The court, therefore, should grant the review in this case. So again, a very important challenge is now moving forward in the Supreme Court. It's currently scheduled for conference at the Supreme Court on December 12th, along with another SBR/NFA case called Robinson. So two NFA SBR cases are going to the same conference, and they're both going in front of the Supreme Court for their consideration. In both cases, the Trump administration filed their responses arguing that the petition should be denied, but then they also argued for the court to take review and address the whole arms ban question in a different case, maybe like a state rifle ban challenge. So it's going to be interesting to see what does the Supreme Court ultimately decide to do in these cases. Like I said, I anticipate that they will deny review to both of these cases. They're probably going to take the Trump DOJ's recommendation to deny review. But at least if they do deny review to these cases, hopefully maybe you get a statement or a dissent from someone like Justice Thomas or someone else making a statement about this whole arms ban question, because that's a big issue that needs to be addressed. And for a long time, we've been trying to get the Supreme Court to take review of like a rifle ban or a magazine ban. And here you have the Trump DOJ saying that, yes, that needs to happen, but just simply don't take up this case. So again, we're going to wait to see what happens in December. But as we get more information, as it develops more, I will let you guys know. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars. and this nation will be maintained by armed scholars.